Well, thank you all for being here. We're going to continue talking about M&A issues, but maybe not focusing specifically on the tech sector. And we have this provocative title, right, for our panel, which is Closing a High-Profile Deal. And as we were having the conversation with respect to organizing the panel, one of the first big questions was this question of, well, how do you even define a high-profile deal? And we'll get to the question of how do you then open a high-profile deal, but before you can figure out how you open it, how do you define it? Michael, I'll start with you.
Hi, everybody. Happy to be here. So what are we talking about here? I think in a lot of ways, a high-profile deal is just like any other deal, but the things that set this off from other deals are really, I think, that they attract the attention of people that are kind of external to the deal itself. So shareholders, regulators, the press, activists of various sorts. So that's kind of how we were thinking about it.
Do you think about it in the same way?
Yeah, I mean, I guess I do. All my clients are like children, so I love them equally. So I try not to think of any of them as high profile, but I can't help the fact that others sometimes do. And so, yeah, I mean, I think it's a level of scrutiny that you get and a level of attention where you can't sort of do things in a more subtle and quiet way, and that sort of pervades the entire transaction.
So Sarah, did you know whether a deal is going to be high profile from the very outset? And if you know that, right, it gets to this question of like, how do you launch it or how do you open this type of high profile deal?
So I mean, sometimes you do, from the outset, it's going to be a huge headline grabbing deal, but sometimes it can, there can be issues that come up after you've announced your deal that then put your deal into the spotlight. Sometimes it can be a positive thing. Other times, there might be a big issue with the target, security breach or management issue after signing up the deal that then thrusts it into the limelight. So you do have to be prepared at the outset, whether your deal is a high-profile one or not, that it could become one.
So Sarah said all of the smart things that I was going to say, and now I'm going to have to regroup a little bit. No, I completely agree. I think some of them are so obvious from the moment I start working on them.
Twitter, Elon Musk.
This is going to be, right, yeah, Twitter, Elon Musk, like that's going to be high profile. Salesforce buying Slack, going to be high profile. And then so sometimes it's the companies involved, and that tends to be household names, name brands, consumer goods, things that impact people's lives on a regular basis. Airlines, groceries, believe it or not, are really, high profile because day in, day out, people are in the grocery store and out of the grocery store. So I think that sometimes it's a company, sometimes it's players involved that make it more interesting, more high profile, or that attract more attention from the media, for example. So like, if some industrial conglomerate bought the Boring Company, that would be a high-profile deal, not because of some like enduring love of tunneling among Americans and consumers of media, but because Elon Musk is involved. So I think that some of them are clearly, obviously high-profile from the start, and then a deal that may not be high-profile gets an interloper, gets jumped, for example, all of a sudden. Big high-profile deal.
So if you know or expect from the outset that the deal is going to be high-profile, how do you sort of think about how you advise that company from the very beginning of maybe the negotiations and the launch and sort of how they document and go through the process of a deal? How much do you think about that aspect of it? Is it any different from when you're doing your kind of standard transaction?
So I'll leave questions about documenting things
to the lawyers
on the stage. You don't want PR guys dictating document retention. But I think in terms of how I look at it, I think I try to take the view that it's the same. There are different elements about every transaction that require you to approach a launch slightly differently. And one of them is the amount of media attention you're going to get. And that just means you need to prepare a robust media engagement plan. More robust, for example, than maybe like a more straightforward go private, all cash go private, right? Where there's going to be very little media engagement. Story kind of tells itself. But it doesn't change the fact a deal being high profile doesn't change the stakes for all of the stakeholders. Being high profile doesn't make it higher stakes for the employees, for your shareholders, for customers. And so whenever you're thinking about launching a transaction from a communication standpoint, it needs to be meticulously planned. You've got to figure out who are my stakeholders, how do I normally communicate with them, what are their concerns going to be, and how do I address those up front? Because thinking about how do you close a high-profile deal, and from where I sit, the vast majority of that work happens at launch. You don't get a second chance to make a first impression. But that's really it. You've got to think about it. So you got to think about shareholders and what are their concerns about valuation. They want to know, are you getting the best price? Did you run a process? Is somebody else going to potentially be interested and jump in here? Employees are going to want to know, am I going to get fired? Am I going to have to relocate? Who am I going to report to? What happens to my RSUs? Customers are going to want to know if you're going to raise prices. Are you still going to service these products, et cetera? You got to think about all of those things in advance and prepare for them and communicate from the outset effectively around each of those key stakeholder groups. Because if a deal is not high profile, but then becomes high profile afterwards, you've missed your opportunity.
And I agree,
Yeah.
It really is, even from the lawyer's perspective, a lot about the communications. There are some aspects in the documentation that, will be driven by the fact that it's a high-profile deal, and that'll depend on why it's high-profile. Is it high-profile because it's two significant competitors doing a deal, and then you're going to be thinking more about the antitrust provisions, for example. But a lot of it is communications, including heads up to regulators, heads up to state agencies, and the like, to really get ahead of the issues.
How do you then advise a board about all of these different aspects from the outset of a deal that you expect and they expect most likely to be high profile?
I mean, I think the advice doesn't change that much. I think the manner in which you have to deliver it and defend it can change quite a bit. So, I come at this more from a capital markets perspective, doing more IPOs and M&A, but on a deal that's sort of falling under the radar, it's very easy for me to say, hey, here's the communication plan, here's what you can't do, it's going to be fine, here's your no comment, don't talk about this, don't talk about that. And everybody says, great, because nobody's calling them and asking them any questions anyway, so it's super easy. But then when they're, a very high profile deal and it's the first day of trading after an IPO and they're going on 50, interviews, of course they're going to be like, well, that's not good enough. That, I need to be able to speak to it. And I'm sure we're all going to bring Elon into every discussion today, but I'm sure Elon was told, maybe don't talk about the deal while it's pending.
Or don't tweet it.
Don't tweet about the company that you're trying to buy while it's pending. And I'm sure the legal advice didn't change very much, but the ability to convey it in a way that actually was heard was probably pretty difficult to manage. And so that is one of the biggest aspects here is my legal advice is on point regardless, everyone should know, but a lot of times it's disregarded in higher profile deals.
Is it more disregarded in higher profile deals, or is it like an Elon exception?
I think I'm going to avoid commenting on the Elon exception. I think that, it's a good point, right? The issues that present themselves in these deals present themselves in lots of deals. I think you got to really, though, understand, as Sarah was saying, what is it that is making this a high-profile transaction? For instance, if it is the risk of shareholders opposing the deal or of an activist trying to get a bump in connection with the deal or block the deal, you're going to think about shareholder communications. You're going to plan from a legal perspective around the vote that you need to get and how you're going to get it. I think there's a lot of people I talk to think that there may be an increase in going private transactions in the near term. And a lot of those have a controlling stockholder or a significant stockholder. So that's probably going to attract more attention. And so you got to plan around the shareholder vote. So I think you need to get Jed in early so that your communications strategy is set up well. You can pay me later for that referral. You also need to think about, are you going to have a majority of the minority vote? And if so, what kind of leverage does that give an activist? And then think about how you can manage around the leverage that gives an activist. So sometimes you will adopt a pill, a poison pill, so that an activist can't accumulate too big of a stake. So you got to think about, as Sarah said again, what's driving the attention your deal is going to get, and then how do you create a legal structure to be able to manage through that effectively to get to the outcome of closing the deal.
Yeah, and that makes you have to think about the challenges to closing a high-profile deal probably much earlier, right? In terms of advising the board before they go deep into the diligence and the negotiations and the drafting and all of those types of things, because you're constantly thinking about all of these different blocks that might be thrown in your way.
Yeah, I mean, I think with everything we do, you need to, this just fits right into that. You need to understand what the party's objectives are and then see around corners to figure out what the challenges are going to be to achieving those objectives. And in this case, you're right. At the very beginning of the negotiation of a deal like I'm describing, you need to be planning for the end of that deal.
At least for me personally, I sort of live off of constant fear. It's really the only thing that gets me up in the morning. And the fear in a high-profile deal, of course, is that anything that you haven't thought about ahead of time, that you haven't planned for, that you didn't anticipate properly, of course, that'll be pointed out and could ultimately become a reason for the deal to fall apart. So it's also strange that the larger and more high-profile the deal, sometimes it's hanging by a slighter thread. Whereas a lot of times in other deals, you can sometimes make the decision to, well, we'll figure that piece of this out later. You know what I mean? Like, well, we'll announce the deal and we'll leave that because we're relatively sure it'll get solved. That's a lot harder to do in a very high-profile deal. So you need to sort of have not just plan A, but plan B, and at least from the lawyer perspective, not being able to communicate to the parties exactly what we're going to do if this regulatory approval doesn't occur, or if these shareholders require more time, we have to adjourn this meeting for approval. All of that has to be sort of pre-baked in a way that sometimes you don't have to do in other deals. And so, again, from a fear of failure perspective, it changes the way you plan.
Sarah?
Right, and when you're in talking with the board, making sure everybody understands to the point of if A, that here's plan A and plan B, and kind of game theorying everything out, because especially in these times, you're representing a target, and then you sign up a deal, and then the buyer gets approached by somebody else to take them over, and figuring out how you're going to communicate to the public, to your constituencies about those issues and what it means for the company.
Yeah, one of the things I think, excuse me, is most interesting is the kind of real-time media dynamic around a high-profile deal. From the standpoint of, a simpler, more straightforward, all cash go private transaction, like all you really, generally need to prepare your client for is the fact that like the journal does not use enterprise value. They only use equity value. It doesn't matter how big that number is that you put in the press release, they're not going to put it in the article. So, but then when you've got a higher profile deal, it starts to become a lot more about, okay, what perspectives are starting to take hold in the dialogue, and who's going to take a pot shot at the deal just so that they can have a contrarian view, and what's going to really upset the board. And so being on top of every single one of the inquiries that comes in and trying to understand kind of where the slant of the story is going, and pulling together the appropriate resources to try to work with them, and to all the best you can hope to do is get balance. That's really the best you can hope to do. And so you've got to make every effort to do that. But that's constant. I mean, you're reading stories, finding mistakes, oversights, looking for opportunities to add balance. You got to jump on them and act on them right away. So a lot of it is just real time.
That also brings up a really challenging thing with some of these deals, which is talking about the challenges of the communication from the launch all the way through the closing. But all of that communication also has really large implications for after the deal closes in terms of integration and integration planning. And so how do you get, and what are the processes that you might use to sort of have your clients be focused on both the negotiation, the getting the deal to a close, but then also thinking about the after effects. Like once the wedding is done, they still have to live together. So from an integration planning standpoint, where does that integration planning fit into your strategy?
So, integration planning, I feel like, is more conceptual. Integration is more tactical. So, this is really one of the more interesting dances that occurs between launch and close. And during that pre-launch period, specifically for like a target company, for example, you want to know, how am I going to answer a variety of questions for my employees? Things like, am I going to have to relocate? Is my insurance going to change because I'm thinking about the doctor that I take my kids to, and yada, yada, yada. So you're thinking about all of those questions, and you want them answered as completely as possible, but it's simply not possible to answer all those questions on day one. And so it's really about finding out, like, how far can you go with the other side initially? Like, what kind of commitments are they willing to make? Sometimes it's, compensation won't change within a year of the closing date, and sometimes it's not quite that generous in terms of what you can communicate. So, it's a push and pull. It's really like pushing and seeing how far we can go as communicators, but then also understanding that you have to equip the people who are going to be answering the questions with the tools to kind of sidestep and avoid those questions and to keep people calm and focused. Because that's a huge element, is keeping, and I'm talking very specifically about internal communications here, is keeping people calm and focused. The team needs to stay focused. They need to execute. You can't have missteps. You can't have people distracted and have FUD take over during that pendency period.
Does that get translated into the contract negotiation part as sort of you're thinking through it, right? How much are you going to protect the employees through the contract and things like compensation and healthcare benefits and all of those things that they care about? Yeah,
those issues are often very heavily negotiated. But one thing I was going to say that Jed's comments made me think about, you're talking about the internal communication. The external communication is in all kinds of constituencies is really driven by being on top of integration. One of the very, very few things that I learned in law school is actually relevant to my job is that the success of a deal is really all about how early on did you start working on integration and synergy planning. That success is about getting the deal through court challenges, through shareholder challenges, through regulatory challenges, and then most importantly, actually making the ownership of the business successful. So you really have to start, I think, at the very beginning and thinking about how are you going to integrate the business and how are you going to achieve the synergies. Of course, I'm talking about combining two operating businesses, but how are you going to achieve the synergies that are really the rationale for the deal? And if you can't explain that in a compelling way, then when you get challenged in court on it, and a court's looking at the process that you undertook and whether it was, again, depending on how the court's looking at the deal, is there a fair process here? Is there a fair price here? That's going to be driven by what you can demonstrate on the synergy front in a lot of cases. Your shareholders are going to vote for or against the deal based on that. So it's really a critical piece of the planning. There's definitely some parts that make their way into the contract, but I think more fundamentally, it's about what's the rationale for the deal, and then the diligence you do, the points you negotiate for, those are all then they flow through from that that starting point of kind of what's the rationale for the deal.
I would. Obviously, there's a lot you can do from a systems planning, contractual point of view to try to anticipate these issues. But particularly in high-profile deals, I think one of the things that I see and I try to take a step back from is, and this is true in M&A, it's true in IPOs sometimes in terms of whether the company is the right fit for the public markets, is do you really want this transaction, or has the high profile nature sometimes sort of made you think you want it more than you should? And so I've had a lot of clients who it's sort of like the end of The Graduate, right? At the end, they're like, yes, I got that person to not marry the other person and go with me, but then they're totally unhappy with it. So it's like there's a very serious cultural question.
Yeah.
You try to step back and say, like, ignoring winning here and sort of doing everything to show that you can make this deal occur. Like, do you really want this at the end of the day? That's a hard thing for a lawyer to convey to a board, but getting the conversation going amongst principals, I think, can have a lot of value. And I do think that no amount of planning can sort of undo cultural sort of fights that are going to come over the years. So preparing clients to understand, in mergers of equals, for example, like, I'm sorry, there's just no way that your two wildly different cultures can just figure out a way to work it out. Like, somebody's going to need to figure out which of these cultures is going to sort of dominate the other one. And so I think those conversations are very important before you get too far along in the process, and then there's no turning back.
Sarah, you want to chime in?
Yeah, I mean, just two things I wanted to follow up on. One is, if you look over the past 5-6 years plus, particularly in tech, the employee constituency is just, has really come to the forefront, and time and time again, and frankly on capital markets or M&A, we want to be transparent with employees. We want to tell them what's going on, and you don't always have all the answers. You can't guarantee they're going to have a job or whatnot, but we found a lot of time taken to communicate, sometimes over-communicate with employees, number one. And then number two, just on the integration point, one thing, from the lawyer's perspective, we're always kind of working with clients on is everybody does want to integrate from day one, and really what we've seen in the antitrust environment is a high degree of focus on what information have companies shared with each other even before signing, including on employee salaries and things like that. So making sure people are putting processes in place and educating people on the importance of staying within those guardrails to achieve what they want from an integration perspective, but also protecting against a regulatory issue down the line.
So in our prior panel, just moving a little bit away from high-profile deal into kind of more M&A discussions more generally, we discussed a lot about sort of how the hot M&A market, particularly in 2021, has cooled down some in 2022. Some of this is because of uncertainty in valuations, and some of this is because of issues with respect to access to financing. So how are you seeing that play out in the deals that you're doing now, particularly the financing issue, which is something we didn't talk about much in the first panel, and how is that impacting how you're advising your clients about getting deals closed?
Well, financing is really a huge challenge now for deals, for sure. Debt financing, absolutely, as well as equity financing. A lot of deals used to get done by putting together huge equity financing consortiums, and those are harder to do as well. So it doesn't mean that deals aren't getting done. I think there are a number of deals that have gotten done and we're involved with that we hope will get done that require debt financing, as well as in some cases equity consortium. But it's harder to do. Direct lenders are playing a really big role in the deals that do get done these days. And it just takes a lot of work. I mean, it used to be you could put a deal together in a matter of a week or so, and that's not really happening these days. So time is a big one. Price is big because when you can get the debt together, the interest rate is really a lot higher. And then people worry about closing certainty. I think people still don't worry a whole lot about closing certainty when they've got a traditional debt financing commitment letter, but some deals are getting signed up without committed financing, and then we're seeing a lot of creativity around conditionality related to raising debt financing. Sellers still don't want to have any kind of actual financing condition, but there are ways of being creative to provide the buyer with some comfort on that issue. But I think the headline is one of the reasons that we're not seeing the number of deals we saw a year ago is absolutely because of debt financing being harder to raise.
So are you seeing things like more reverse termination fees or higher types of termination fees and so forth if you don't have financing conditions, or sellers at least asking for that to begin with, especially given the focus from the Musk Twitter deal?
I think that you're seeing the kinds of things related to a business that could result in the financing not coming together that traditionally would be a buyer's risk are sometimes being a seller's risk. So think of it like sort of mini-Mac kinds of issues. Sellers are fighting hard against that, for sure. I think we'll continue to do that. But when there's a good deal to get done and say, a good 18 months of regulatory approval required to get it done, you might be willing to take a little more risk that during that 18-month period, a buyer's going to be able to get financing.
Sarah, how are you seeing that?
Yeah, I mean, one thing, and people have always worried about this and always negotiated in the contract regarding conditionality and the like, but you have seen recently a greater focus on the target side of worrying perhaps if a buyer has buyer's remorse that people may look to a financing source. And again, not a whole lot new in terms of technology and drafting. It's really been the same issues, but more of a focus on those types of considerations, particularly when it is a volatile market where the buyer may be very excited about the deal at signing and think it's a great deal. Markets shift on them and they might be less than enthusiastic.
Does that impact then the communication both internally and externally, given the fact that financing is more uncertain and you've got more regulatory scrutiny, and so the deal might take a lot longer, and so your communication plan has to kind of consider this additional length?
No, I don't think so. Excuse me. Not really, because you got to set the tone from the outset for how long it's going to take, the expectation for how long it's going to take, and you got to keep people engaged along the way. And you have to be mindful of how hard you try to keep people engaged along the way, because there's a cadence to it and there's a balance to it. And you don't want to over-communicate about a transaction to an employee base, because eventually that's all they're going to be thinking about. And then we're back to what I was saying before about risking integration or risking execution. So I think that's interesting. One thing I was thinking about as we've been sitting up here talking is I had a client, a consumer products company, that launched a strategic alternatives process, a public strategic alternatives process with very unfortunate timing right before sort of the market troubles, as it were. And the worst part about running a public strategic alternatives process is that if it doesn't work out, you have to say it didn't work. Nobody wants me. And so you kind of issue a press release that says it. And so that's where we ended up on this one. And we had to announce that we're concluding the strategic alternatives process. And we were very clear in that communication, maybe in more detail than you might typically be, all the reasons why. And it's really a litany of all we've been discussing. Private equity buyers, financial buyers couldn't get the financing. They were interested but couldn't get the financing. Strategic buyers either were dealing with their own market volatility or were too busy absorbing prior acquisitions and dealing with integration issues that were stemming from all of these same things. So, that was terrible timing and really unfortunate, but it really, I think, kind of codified everything we've been talking about so far.
So in addition to the valuations and financing issues, there's also a lot of uncertainty in terms of geopolitical instability, spiking inflation, which impacts financing, but supply chain issues, skittish capital markets, regulatory challenges, all of those types of things. Dave, maybe I'll start with you. How does that combination of uncertainty and the fact that deals are just slowing down impacting your clients and impacting your practice?
Yeah, thank you for that great question.
You're so happy.
Yeah, how do you deal with Armageddon? I mean, look, it's a really a challenging environment, and I think when you're going into a transaction, knowing that there is so much fluctuation in the market, there is so much regulatory uncertainty, and frankly, there's just like sort of ambient fretting about all things, right? Uncertainty just breeds, sort of more contention amongst the parties. So even parties, which I have no reason to assume you're going to do anything wrong, and no reason to assume you're going to do anything wrong, but we're both beholden to the wildness of sort of the world around us, and so I want to protect myself and you. So it's just a contentious, sort of difficult process at the beginning, and at least what I try to do is set expectations with clients, set expectations with the other side of, I promise you we're all going to work towards the end goal here as fast and as efficiently as we can, but let's not set ourselves up for failure on the things we can't control. So, if we're doing a de-SPAC transaction and everybody, and I get the typical, board or management question of like, well, I don't understand why we can't get through the SEC in 60 days. And then I explain to them that I don't know what to tell you other than the fact that it's going to take, add 45 days, and then maybe add 20 more just in case. And that's a hard thing to do, particularly when people want to get results and they want to get to the fastest possible answer. But I think it's important that uncertainty just costs time. Time creates more uncertainty. It tends to sort of fall on top of itself. And the only way around it, I think, is just sort of assume a bunch of different scenario plans that include things that you might not have seen if you were looking at a deal 2 years ago.
So maybe for you, Michael, what are the scenario plans that you're thinking about in terms of assuming, given the uncertainty? So the risk of your deal being jumped and things like that. How are you integrating that into both the negotiation process? Because if everyone's hedging their bets, everyone's trying to protect themselves, and everyone's thinking about the other way that the other person's going to backstab them, right? So, or some third party, right? So how are you seeing that reflected in the negotiation and in the contract? And are there certain kinds of tools that were maybe previously used in the past that are coming back into vogue and so forth?
Well, I'm much happier to talk about deals getting jumped than the impact of war and such on deals. I think on the latter and the geopolitical issues and the like, I think the biggest place where that hits is in timing and the care that people put into diligence and sensitivity cases, and what happens if something happens with China and that part of the world, and does that have an impact on the global economy the way that the war in Ukraine has? I think those are things people have to be very careful in thinking through. Understanding the exposure of a business to supply chain issues has always been important, but the last couple of years have really highlighted the importance of that. I think most of that relates to diligence. For the most part, I think buyers are still taking risk of geopolitical issues in contracts, although if those have a disproportionate effect on the target, then they probably aren't taking that risk. Deal jumping is much easier territory for me to talk about as a deal lawyer and not a politician. But I'll stay away from that since the question was about geopolitical stuff.
Yeah, I mean, it's interesting because some of the geopolitical issues, have resulted in an increase in activity. For example, as companies are looking at their China operations and whether there's a desire to divest, or as companies work to solve their supply chain issues by engaging in M&A activity. I mean, just the increase throughout the world, really, in terms of focus and foreign direct investment review and regulations in Europe really has changed the deal landscape. And interestingly, has changed some of the financing landscape too, as sometimes people are taking a harder look at the financing sources. Where are they located? Are there any foreign investment reviews associated with those? So we've seen a lot more time and analysis taken in some of those areas, and then with some deals not getting done because people don't want to take the risk of signing a deal that they're not sure will close.
And while smarter people than me are thinking about geopolitical risk, I just go talk to IR because I want to know who's in the shareholder list. Like, who are your shareholders? Are any of them vocal? Are there any of them who have been pushing for a sale or have been pushing for you to do something different? Who shows up on your conference calls? Because you can just get that list. So who's been lurking on your earnings calls? So those are the kinds of areas of risk that we think about as well as we're approaching like a deal launch. Is who's already in the stock who might hate this?
So is that the uncertainty obviously impacts like shareholder communication and shareholder approval and the opportunity for shareholders maybe to get a better deal from somebody else. So maybe you can talk a little bit about the deal jumping issue, right? But also how that relates to how you think about the shareholder approval part of things.
Sure, yeah. I mean, I think that, look, if there was a deal now if there was a target company now that was in play and you had more than one buyer that could buy it and really wanted to buy it, I think you could see some really aggressive movement to try to win that asset, just given how rare deal making is right now. So I think that as you're negotiating a deal, you need to be really careful in understanding who the potential interlopers would be and really plan for that. There's a lot of stuff we've been putting in agreements for a long time to deal with that, but I think there are additional things to think about in today's environment. So how you define what constitutes a superior proposal that the target is allowed to take. Usually those are things that people don't worry too much about, like do they have debt financing? Is that debt financing committed? Well, I think that you're going to have to dig into issues like that more now than you used to. Regulatory approvals are harder to come by now, antitrust as well as foreign investment, as Sarah was saying, in the US as well as around the world. So there are some issues in the details of merger agreements that govern how you evaluate competing bids that people, I think, too often overlook, but warrant really taking a deeper dive into right now. I don't think there's a lot going on in the world of deal jumping. I guess setting aside the Spirit airline situation, which mostly predated, I think, a lot of the stuff we're talking about. But I think we probably will see more public company M&A, and I think with that will come a lot of consideration of some of these issues.
Sarah, are you seeing it in the same way where you're paying up, I guess, more attention to the nuances of specific deal protection provisions in the contract and sort of maybe seeing one of the we academics, at least when we're looking at this, we're seeing it as sort of a lockup creep, like a creep in terms of ways that people try to keep the deal closed or get closer to closing and manage some of these uncertainties. Are you seeing that in practice?
So I think people are still have always paid a lot of attention. I think what has changed a little bit is as you see examples of things that didn't happen historically that happen, people kind of relook and say, oh, well, I thought deals would go this way and now one has gone a different way. Or, you see, for example, the Memento Zendesk deal, the buyer shareholders voting it down. So, I mean, when you see examples of this, I think it also focuses the principal's attention on the issue. So again, I think people are paying as much attention as they always did, but when you have some of these things where people thought were corner cases, maybe not so much a corner case, it renews attention.
Does that make you not able to sleep, Dave?
It's stressful. Look, tough markets always sort of disempower management teams versus shareholders, and there's just no doubt about it. When everything was, when the results and everything's up and to the right, like CEOs get to sort of ignore ISS and Glass Lewis and get to not join phone calls with large investors, and now everybody's scrambling to figure out, who they need to talk to tell them why their core business is still strong. So it's an entirely different dynamic, and that goes to deals, but it also just goes to public company like maintenance of their existence and approvals for additional shares to grow with and all sorts of stuff. And yeah, I like it the other way for my clients.
All right, well, please join me in thanking our panelists.
Thank you.
Thank you.
Thank you.